Hello, Brian Weekley here again from Snow, Carpio, and Weekley, statewide Arizona workers' compensation attorneys. We do cover the entire state of Arizona. I've got 32 years of experience in Arizona workers' comp law, and I am a certified specialist by the State Bar of Arizona. I wanted to talk about what happens at an industrial commission hearing, what that process is. A hearing comes up, it's raised in a variety of different ways. If a claim is denied, and you request a hearing. That's called a compensability hearing. If benefits are terminated, if medical benefits are not provided, if compensation benefits are not paid, if compensation benefits are underpaid, if there's an issue about permanent impairment or a permanent award, those are issues that all come before the Industrial Commission of Arizona ALJ division, and ALJ stands for Administrative Law Judge, so ALJ division. It's assigned to a judge, and the judge notices a hearing. She or he sends out a notice of hearing. Before COVID, those hearings were in person, and they occurred at the Industrial Commission of Arizona at 800 West Washington in Phoenix. There are a series of hearing rooms there. In the era of COVID, those hearings have been moved to a virtual format. They take place through Google Meets. It's an app, a platform, if you will. The parties have a code. The parties and their attorneys enter the code, and then a video meeting comes up, and everybody's in their little box by video, and then the hearing takes place. The administrative law judge is an attorney licensed in Arizona, and he or she has been hired by the Industrial Commission as an administrative law judge, and they primarily only hear workers' compensation cases, so they're very familiar with workers' compensation laws and workers' comp cases. When you're assigned a judge and a hearing is set and the hearing begins, the judge usually summarizes the issue and says something like, "We're here today. The insurance company issued a notice closing John Doe's case on October 7th with no impairment. John Doe protested. We're here today on the issue of continuing benefits." The first witness is usually the injured worker, also known as the applicant. The applicant is then asked a series of questions. If the applicant is represented by counsel, the applicant's attorney, which would be me or somebody like me that does applicant's work, asks the applicant a series of questions. In my own cases, I provide an outline before the hearing to my clients so they know which questions I'm going to ask, and we discuss the questions before the hearing so there are no surprises. So the applicant's attorney asks a series of questions, and the applicant answers these questions. And then the applicant's attorney says, "I'm finished, no more direct exam." And the insurance company's attorney then does cross-examination. Cross-examination is questions from their side, and those can be what we call leading questions as well. When the defense attorney's finished, the applicant's attorney can then ask, it's called redirect, and there can be recross as well, even though that's fairly rare. So there's a series of questions. If you have no attorney, going through the hearing process is not a good idea. There's a lot that goes on that you can read up the rules, and you can look at process and procedure, but so much of what goes on in a hearing is just based on custom and how things have been done and normal practice. So going to a hearing unrepresented it increases the risk of loss, I think, exponentially. You want to be represented by a competent attorney who knows her or his way around an industrial commission hearing room to put your testimony in the best light possible. More importantly, if there's medical testimony that's at issue, medical testimony is generally trickier than applicant testimony because it involves medical terminology and medical opinions, and you're direct examining and cross-examining experts in their field. So it's a whole different level of evidence. So initial hearing is normally just the applicant testifying. There may be other witnesses, which are called lay witnesses, non-expert witnesses that testify. Usually if the issue is compensability or whether an injury occurred by accident arising out of and in the course and scope of employment. Other hearings are generally just the applicant testifying. There are then further hearings for the medical experts. They testify normally by phone, and they testify about their opinions about the case. For example, John Doe needs surgery. John Doe's surgery need is related to his industrial injury. That would be a typical bit of testimony. And then the independent medical examiner would testify at another hearing further down the road by phone about his or her opinion. Doesn't need surgery, or the surgery is not related, or it's not related to this injury, or whatever their opinion is. After the evidence is completed, it's considered submitted, and the judge will make a written decision. Any party that is not happy with the decision has 30 days to request review of the decision. But that's an entire different process. I'd have to do I could do an hour just on appeals and request for review. It's a different specialty, and there's a lot of different things to it. But the hearing process itself merits professional help, no matter how big or small the issue, because once you lose on most of these medical conflicts, there's not going to be an appeal. Technically there's appeal, but practically speaking, it's not going to be an appealable issue. Anyway, I hope that helps. Call us with any questions.